Bill 1720.
Yes. Awesome. Thank you again. And today I'm also introducing HB 1720, which will eliminate the waiting period for divorce on grounds of abuse and neglect. Under the current state law, Virginia is seeking a divorce from a spouse who has been the perpetrator of abuse, cruelty, threat or bodily harm, or willful neglect must wait a year after such an act before they are eligible for a full divorce. HB 1720 simply just strikes the one-year stipulation from these undeniable justified grounds for divorce to allow those who are the victims of spousal abuse to acquire the freedom and safety they deserve. According to the CDC recent surveys on intimate partners and sexual violence, almost half of all women and men in the U.S. have experienced psychological aggression by an intimate partner in their lifetime. The impact and ramifications of spousal abuse are almost impossible to track behind closed doors, and while a waiting period for certain legal proceedings is understandable, protecting the status quo is not worth the cost of even one person feeling trapped or defenseless, and God forbid they are assaulted or worse. For too many suffering from sustained abuse, the only legal avenue to end this behavior is to give survivors an expedited way out at little cost as possible, since they have, God knows they have paid the price already. And today you will hear that there are additional legal options available to those who desire a divorce already, such as taking advantage of the temporary separation while the clock keeps ticking on the waiting period. While we have worked with various stakeholders to try to find a middle ground, I have heard from the survivors firsthand, and these alternatives are not enough, and I am not content just to stand by and do nothing. So thank you for your time.
Thank you, Delegate Clark. Do you have any members have any questions for Delegate Clark?
I do have people prepared to speak as well.
Okay, great. Anyone here in favor of the bill? Please come forward.
Hello. I guess you guys know now. My name is Mary Attanat. I should also tell you that I'm a domestic violence advocate. I'm also a human trafficking advocate, anti-human trafficking advocate. I am very heavily involved in our policy tables. And wherever this wrong is happening to victims, I will be there. So I'm here in support. Didn't know I was showing up today and I would be having the field day because everything that I support or I'm against, it's happening today. So good luck on me. Thank God for me. And yes, I support. Thank you.
Thank you. Anyone else here in support? State your name for them.
My name is Makya Little.
Thank you.
My rent is 2 weeks past due. Both of my personal credit cards are maxed out. And I owe my retired parents more than $10,000 and counting. The man I used to call my husband and my college crush has a warrant for his arrest in South Carolina for assaulting me while we were on vacation in 2021. Yet more than a year later, he still has control over my ability to access my own retirement savings account because our system has kept us tethered and allowed him to shift his physical abuse to legal and financial abuse. Had it not been for the fact that our family home was in my name and my name only, I had the privilege to change and hide my address. And had it not been for the love of my parents, who refused to allow their daughter and their grandchildren to be homeless, we would be. I am not alone. More than 30% of Virginia's homicides are related to domestic violence. According to a VA data report in 2019, more than 22,000 adults and nearly 5,300 children received domestic violence advocacy services in the Commonwealth. A total of 20% of the people who received these services had to relocate or experience homelessness as a result of domestic violence. 87% of domestic violence perpetrators in Virginia were men, and 13% were women. I am using my privilege to speak for the voiceless and those too battered to fight both this archaic system and their spouse at the same time. I'm asking you to use your privilege as their representative to help save our lives. There are hundreds of thousands of lives you have the power to save. Voting against this bill doesn't just make you complicit in our abuse, it makes you co-abusers. I plead for your vote to advance this legislation, if not for us survivors, then for the millions of children in the Commonwealth who have to face a parent with visible, psychological, financial, emotional, and legal scars. Will you vote for survivors, or will you vote for the attorneys who profit off of our abuse?
Thank you, ma'am. Anyone else here in favor of the bill? Anyone here in opposition to the bill?
Good afternoon, Mr. Chairman. Richard Garrett with the Family Law Coalition. We're opposing this bill. The proponents who spoke in favor of it gave passionate stories and horrible stories, but they're talking about domestic abuse, and we're really talking about apples and oranges here. Under the regime that we have in Virginia regarding getting a divorce, if you make a divorce for cause, that is desertion, cruelty, with the exception of adultery, even with adultery, you can get into court. You can get an order from a judge. You can get support. You can begin litigating the case. What this actually does, if you take away the 1-year waiting period, and I've seen this happen in adultery cases, where a party, and in fact it happened in the city of Chesapeake, with a nameless attorney that Mr. Leftwich and I know, she filed a case for adultery, only for adultery, asking for a final decree of divorce. She litigated it. She didn't meet her burden of proof. The case was dismissed. Her client was left with no legal remedy, had to begin all over again. And that's exactly what can potentially happen when you take away the waiting period on this one issue. I will state, while it's not germane to this bill before us, in the discussions that the coalition had regarding this bill, there were discussions about beginning a study on our own to study whether or not to revisit the need to plead fault to be able to get into court before the 1-year waiting period. And we're hoping to come within the next session with potentially a bill proposal on that issue. But right now, this does not solve the problem that Delegate Clark wants to solve. We have a solution for that. It's called an emergency and permanent protective order. The court can give temporary support under that in the juvenile court. Currently, if you are going to allege cruelty, and delegates that practice in this know very well, one battery under the law in Virginia does not make a case for cruelty. It is very complex, and it is very difficult to prove a case for cruelty, even in a divorce case, at the level of proof that is required there. And I think this is actually going to potentially put more people in harm than leaving it alone at this juncture. Thank you.
Mr. Geary, let me ask you, under existing Virginia law, assuming a party was guilty of physical cruelty against another, doesn't existing Virginia law allow for a judge to enter a divorce decree at mens authoro? That's
correct.
Which would sever the marriage prior to the expiration of the 1-year period upon a showing of that.
The judge can still issue an order a mens authoro which severs the legal relationship between the parties. It doesn't adjudicate between the equitable distribution. In all practicality and the way the courts move, what happens is by the time a judge is ready to issue a mens authoro, the 1 year has passed. It can be automatically converted to a vinculo matrimoniae, and everything is finalized at that point. So at this juncture, there's no bar from anyone getting into court and getting the relief they need pending the final divorce.
Thank you, Mr. Geary. Delegate Anderson, you have a question?
Mr. Geary, just almost an identical question to the chair. There's also could be relief pendente lite as well, correct?
That's correct.
I mean, you don't have to You don't have to wait the full year necessarily to file a regular divorce complaint and get pendente lite relief within a month in most
That's
circuit
correct.
courts, correct? So the last speaker having problems with her retirement account, that relief could be brought in front of a circuit court judge very quickly, and a circuit court judge would have the power to adjudicate issues like that if there was something going sideways, correct?
The circuit court judge would have the power right now to adjudicate issues of support and order support be paid to anyone. The only way a circuit court judge could, pending a divorce, invade a retirement account, I know there is case law directly on point that a qualified domestic relation order, can be entered to invade a retirement account to pay back or current child support. I can't sit here and say that I'm aware of one for spousal support, but I know I would make that argument because I know there's a case dealing specifically with child support. So there are many avenues already available to people to get the relief they need from the court under the current law. And as I said, personally, I'm not speaking for the coalition. Personally, as a practitioner on this, I would like to revisit this. I'd like to revisit the need to file cause-based divorces to be able to get in for a mens et thoro, because I think we would resolve a lot of cases quicker, not having to necessarily argue cause as a fundamental part of the pleading. Cause can still be adjudicated and tried because that's one of the issues the court looks at when awarding equitable distribution or spousal support. So, but there's no barrier right now keeping litigants from getting the assistance they need from the courts.
Follow up, Mr. Chair, just one more.
Delegate Anderson.
And for a party that might be indigent, that might not be able to hire an attorney to file for a divorce in a contested format in the circuit court, there's quite a bit of self-help remedy in the JDR court that's form-driven, correct?
That's exactly right.
And you mentioned those protective orders. You can file for spousal support.
That's correct.
You can file for child custody, and
Correct.
all of that is form-driven for a indigent party to seek that relief on their own if they wanted to, correct?
Delegate, we see it every day.
Yeah, me too. Thank you.
Anyone else here in opposition to the bill? Delegate Clark.
Thank you, Mr. Chair. And I'll just close out with, I heard a lot today about potentialities of this bill and what it can cause, and that, we would love to look at other studies. But when I look at other states nearby that don't have these waiting periods or have a shorter waiting period, and I see it doesn't hurt those states, and I still haven't heard the question or the concern of what does this hurt by taking away this 1 year waiting period. I have heard all these other remedies that's out there to help soothe these problems, but yeah, I still haven't heard what is the need of the 1 year waiting period and what does it hurt if we take it away, other than it may potentially do something down the road, but yet we know today that there are living, breathing people right now across our Commonwealth that is suffering from domestic violence. So I just hope that we can act today.
Thank you, Delegate Clark. The bill is before us. Delegate Anderson.
Speaking to the bill, as a divorce practitioner, there's no court that I'm aware of where you can file any kind of a divorce complaint and get a hearing immediately. It takes a while, sometimes a year, maybe more. And so these waiting periods may sound arbitrary, but getting into court is very easy for someone to do. And the process is very slow after you get into court. And so for that reason, I don't see the 1 year waiting period as a bar for any person to file their complaint. And that's where my rub on this goes. I'm not going to support the bill only for that reason, and certainly don't appreciate being called a co-abuser by saying no.
Mr. Chairman,
Delegate Simon.
move to report.
A motion is second to report the bill. All in favor signify by your vote on the voting machine. Delegate Clark, the bill would fail a 3-5 vote.
Mr. Chairman,
Delegate Leffler.
motion. I would, I mean, I heard what the advocate said about the bill. I respectfully disagree with them and agree with Mr. Garriott on the practical consequences of the bill. And so I would move to gently lay it on the table. And with the comment that I would like the Family Coalition to look at how we can maybe try to remedy this, as Mr. Garriott indicated they may. Okay.
And I'd love to work with you all too.
No, the closed vote, Bill was defeated. 3-5. No, it's dead. It's dead.
But thank you.
All right, thank you, Delegate Clark.
Can't always be nice.
So we're at the end of the first hour, thank goodness. So we're beginning to say,
Thank you.
the bill was defeated. Right. All right, so does anybody desire to take a 5-minute recess? No?
I'm just kidding.
Why don't we take a 5-minute recess?